Good evening, ladies and gentlemen. My name is Leigh Maingard. I'm the CEO of Intersect Sectional Title Services. Welcome to our free training session tonight. It's the third one for this year. For those people that are joining us again, welcome. And for those who haven't joined us in the past, good to see you present tonight. Please note that this is a 60-minute session. We're going to try and keep it to the 60 minutes. I have put everybody on mute. So if you have any questions, you're more than welcome to put them in the chat box, and I will try and deal with them after the fact. Tonight, we're going to talk about CSOS, reserve funds, and Fidelity insurance. Let's get on with it. CSOS Act and functions of the service. It's important to understand that there is an act, the CSOS Act 9 of 2011. If you go and look at the Act, you'll see that there are 60 sections. Sections 5 to 36 deals with the internal infrastructure management of the body, CSOS itself. So those are not sections that anybody needs to really worry about. The other sections in the Act deals with the conciliation and adjudication processes. If you do have the time to go through it, it's important that you do understand, especially from a trustee's perspective. And also if you're an owner or a member in a scheme and you want to potentially take your scheme or the trustees or the managing agent or another owner to CSOS, it's important that you understand the process. So the process that is included in the CSOS Act deals with the applications and notices to parties concerned. So how do you deal with the applications? What forms do you need to submit? The fees payable in order to get your application through CSOS for them to actually look at it and deal with the actual details of your application. It also deals with how they can reject applications. And that's also very important to understand, and you'll have a look, we'll see in the next slide where they can reject applications. And then also the appointment of orders and adjudications by the adjudicators, how that works and how the application, how they apply that within their processes. And then the enforcement of orders and the right of appeal. So as you know, adjudication orders can be appealed against. And it's important to also understand that when there is an adjudication order, if you do want to proceed with that appeal, because you might know or you might not know, but an adjudication order can only be appealed in the High Court. So it's very, very important to understand when you do go to CSOS what your application is for and that it's done correctly and that you have a valid case. Prayers for relief. So the prayers for relief are the different sections which the Act allows you to do an application. And you'll see there on the right-hand side, you can apply for financial relief, behavioral relief. That would be, for instance, between owners or even trustees, scheme governance, meetings, if meetings weren't held correctly or decisions were taken that were actually invalid, management services, private and common areas, and then general and other issues. If you look at section 39 of the Act, it's actually quite detailed. Each section that you can apply for relief is quite detailed in the Act, and it's important to study that to see exactly what falls under each of those sections, that being financial or private and common areas, etc., etc. And I think this is also where it's important to understand when you do go to CSOS, which prayer for relief you are going to apply for, because if it falls without the 7 prayers, then CSOS will reject your application. CSOS, the Act also has regulations, and the regulations really deal with the promotion of good governance, training, and education. What that really means is that the regulations indicates the duties of scheme executives, Fidelity insurance, the scheme obligation to take out Fidelity insurance. We are going to deal with that a little bit later. Governance documentation, in other words, the documentation that a scheme must lodge with CSOS. So there's an obligation on the scheme executives to ensure that the documents are provided to CSOS on an annual basis, and then when things are changed, for instance, when the rules of the scheme has changed. And then also training. The CSOS Act clearly states that that CSOS itself has an obligation to train executives and other interested parties that deal in sectional title. And then also it deals with annual returns, certificates, and forms. So it provides the necessary certificates, for instance, when rules are changed, and then the forms, the forms that need to be completed and the way that they need to be completed when you do apply for relief. CSOS levies, you'll see there on the screen is a very simple schedule of indicating how CSOS levies are calculated. You'll see there, if you take the very first line, the levy, let's say the levy is 500 Rand. And please note that when we talk about the levy here, we're talking about the primary levy. So this is not exclusive use area levies or special levies or any of those kind of levies. This has purely got to do with your normal admin levy. So if the levy is 500 Rand, your discount is 500 Rand. The factor is 2%, so 2% of 0 is still 0. But if you look at, for instance, a 1,000 Rand levy, so the levy is 1,000 Rand, the discount is 500, which leaves you with a balance of 500 Rand. 2% of 500 will give you 10 Rand. And then you'll note right at the bottom, 2,500 Rand minus 500 will give you 2,000 Rand balance. 2% of that is 40 Rand. 40 Rand is the maximum amount that the CSOS levy must be calculated. So in other words, any levies over 2,500 Rand, even if it's 4, 5, or 10,000 Rand, will still pay 40 Rand as a maximum CSOS levy. And that levy must be collected as part of the levy statements that are sent out to the owners. And then they are payable every quarter to CSOS. And then just the fees. So it's important to just consider this application fee when you apply put through an application to CSOS. Your initial application fee will be 50 Rand. And then if you go through to an adjudication, in other words, your mediation conciliation failed, and you need to go through to an adjudication where an adjudicator will make an adjudication order, then your fee will be 100 Rand. So you'll note that it's a very cheap way of potentially getting an outcome, where a mediator is put in a position to deal with the aggrieved parties. Unfortunately, the process and the time that it takes from an application and to get in front of a conciliator or mediator and even an adjudicator, unfortunately, sometimes takes quite a while. But by far the most cheapest way to get some kind of solution or resolution to any disputes that there might be in a scheme. And then just if you need documentation, it's 8 Rand per copy. And then the waiver of fees, if a net household income is less than 5,500 Rand per month after pay as you earn, then there is no fee payable to CSOS if there is an application put forward to them for relief. CSOS adjudication orders. So there's a host of adjudication orders. You'll see at the end of the slides, I've given you access to directly to the CSOS website where they have adjudication orders that they publish. But what I thought to do is just as an example, is have a look at a couple of adjudication orders to give you an idea of the variety of adjudication orders that come from CSOS. The first example is Bernardi versus Britannia Court. And in this case, there were actually 2 issues. Bernardi submitted two applications to CSOS. One was a damage to the roof, and then the other one was meter readings that were calculated incorrectly. So you'll see on the left-hand side, the damage is from 2015. The trustees were informed of the damages, the repair of the roof. The relief was for the repair of the roof and damaged ceilings. On the body corporate side, they did not appear at the conciliation or adjudication, although they were informed about it. They were aware of the damages for at least 2 years. The body corporate at that stage had insufficient funds for the repairs. What the trustees did do is they called an AGM and voted against a special levy to raise funds to repair the roof. So you'll also note here that some of the other owners were actually part of the issue or the problem here. Interesting enough that the trustees actually did not need to call an AGM to raise a special levy, because the trustees actually have the authority to raise a special levy if they do not have sufficient funds. And then on the right-hand side, you'll see that the adjudication order was that the trustees were ordered to repair the roof within 30 days, and then they were ordered to reimburse the overcharge utilities. So in this case, the owner actually provided CSOS with the calculations, and CSOS were obviously obligated to review that, and they made the adjudication against the body corporate. In the next one, quite an interesting case, the Turner versus the Adley body corporate. The members were not entitled to receive minutes of trustee meetings. So in this case, Turner went to CSOS to ask CSOS to compel the body corporate to present the owners with the trustee minutes. The Sectional Title Schemes Management Act says that the trustee meeting minutes must be circulated within 7 days of the meeting. What Turner was upset about was that they only received the trustee meeting minutes after the next trustee meeting minutes. So just from an operational perspective, the trustees would have a meeting. The minutes will be prepared by the managing agent, I would guess in this case. And then at the next trustee meeting, the trustees would then review the minutes and only then approve that. The problem here is that the next trustee meeting could take a week, or sorry, not a week, a month, or maybe even longer before they actually have the next trustee meeting. So what the body corporate said that what they said was that the meeting dates were listed on the website. So in this case, the body corporate had a website, and on the website, the trustees actually informed all the owners when the next trustee meeting would be held. They also relied on prescribed management rule 9E that says that persons entitled to notice of meeting. So in this case, they argued that persons entitled to notice of meeting in this case means the trustees, and that the members were not entitled to receive the minutes nor the notice of the meeting, although they did put it on their website. So what actually happened after that? What happened in this case is that the parties actually agreed not to continue with this backwards and forwards and involving CSOS, and that they actually agreed that the trustee meeting minutes would be supplied to the owners. What's interesting here is that owners are entitled to actually attend trustee meetings. Obviously, there are certain restrictions in terms of their participation. For instance, they can't vote on items that are discussed at the meeting. But I think what is important again here to remember is that, you know, discussions that are held at trustee meeting level, ultimately the trustees are there for the benefit of the scheme and to serve the owners in the scheme and to do everything to the benefit of the scheme and the management thereof. So I think the objection here by the body corporate trustees not to provide the minutes, you know, in some ways shows that maybe things were being discussed that they didn't want to share with the owners, which I find a little bit disturbing, because ultimately you need to be transparent in how you manage the scheme. But just again, as an example, what type of matter was taken to CSOS. The next one was Sonneveld Atlantis City HOA, and in this case, you'll see that it's a homeowners association. The HOA and here the applicant was the homeowners association, and here they just applied to CSOS for the owner to be compelled to pay the rear levies. The owner did not attend the conciliation or adjudication. So important here is that the fact that either of the parties, the applicant or the respondent, does not appear at the conciliation or mediation or adjudication for that matter, does not mean that there won't be an adjudication made against either party. The main thing for CSOS is always to make sure that they have all the relevant information so that when they make an adjudication order, when they get to that point, that they are able to review both parties' side of the matter. Ultimately, this owner was ordered to pay the real levies and the interest charged to that. Another HOA matter, in this case, it was the applicant was actually an owner. And here it had to do with short-term letting that wasn't allowed by the HOA. So the owner said that the fact that the HOA wasn't allowing the owner to do short-term letting was an infringement of their constitutional rights, and that the rule contradicted the Constitution. And he wanted the CSOS to make an order to compel the HOA to allow the owner to do short-term letting. The HOA on the other side had conduct rules approved where short-term letting of less than 3 months was not allowed. The constitution of the HOA was argued that it governs and administers the HOA. So members of the HOA have to comply with the constitution, and it further implies rules to control the use of units. The CSOS ruled in favor of the HOA, and in the fact that they said that the new rule was deemed reasonable, and that the owner did not have a case against the HOA to prevent them from doing short-term letting. Another example, North Downs Body Corporate. In this case, the body corporate had to reimburse charge levies on account. And the important thing here to consider is Prescribed Management Rule 25.5. So in this case, the North Downs Body Corporate, the trustees approved replacement of keys. So what happened is that Drisner, who was the owner, lost his keys to the access gates. So what happened is that it created a security risk for the body corporate, and it obviously had security keys, which you know that these keys are quite expensive, and you can't just, for instance, replace one. You would probably replace the whole lock. So in this case, the body corporate said, well, it's a security risk. We're going to replace all the keys that were affected. It cost the body corporate 21,900 Rand. And also what happened in the same time is that the owner was in the process of selling his apartment. So the body corporate then went and charged the 21,900 Rand to the owner's levy account. And then when the owner, through the attorney, asked for levy clearance certificate, the body corporate withheld the levy clearance certificate. There was also interest accrued on the 21,900 Rand during that period of 2,100 Rand. The owner effectively paid the 24,000 Rand because he wanted the transfer to go through. But what happened is that CSOS then ruled against the body corporate, and the body corporate had to reimburse the 24,000 Rand to the owner. And the only reason here was because the body corporates were not entitled to raise charges to the levy account that was either not provided to them by adjudication order or by order of court. So that's very important to consider that, and especially from a trustee's perspective and also from a managing agent perspective, is that we're always aware that you can't go and charge charges to a levy account unless you have an adjudication order or a court order against the owner. In this case, Molapisi versus Jabulani Brook Body Corporate, a very simple one. We get this quite often. People don't pay their levies. The body corporate, for some other reason, decide to go and disconnect the electricity. There were two matters actually put forward by Molapisi. The other one was the gate. They decided to deal with the gate issue outside of a CSOS hearing, but ultimately the body corporate was ordered to reconnect the electricity immediately, and that they weren't entitled to to disconnect the electricity from the apartment. All right, we're going to have a look at the reserve fund calculations. And so the Sectional Title Schemes Management Act and regulations is of importance here. Sectional Title Schemes Management Act Regulation 2 must be read and calculated in conjunction with sections 3(1)(b) of the Sectional Title Schemes Management Act. And I'm just going to read what 3(1)(b) of the Sectional Title Schemes Management Act says specifically. It says to establish and maintain a reserve fund in such amounts as are reasonably sufficient to cover the cost of future maintenance and repair of common property, but not less than such amounts as may be prescribed by the Minister. So the reason why this is important is that as you can see in terms of 3(1)(b), it talks about future maintenance repair of common property. And we're all very familiar with the maintenance repair and replacement plan, or your 10-year maintenance plan. So why this is important is that you need to do a certain calculation to determine what your contribution is going to be to your reserve. So here we're looking at Regulation 2, and there are 3 scenarios to consider. Scenario 1 is the following. If the amount in the reserve fund at the end of the previous financial year is less than 25% of the total contributions to the administrative fund for that previous financial year, the budget contribution to the reserve fund must be at least 15% of the total budget contribution to the administrative fund. Now, it sounds very complicated, but what I've tried to do is give you an example of how to calculate such a scenario. So in this scenario, I use February 2022 as an example. The year end is February 2022. The budget contributions for that year is planned to be 450,000 Rand. The reserve fund at February 2021, that would have been the end of the previous financial year, was 90,000 Rand. The total contributions for the 2020-2021 year was 400,000 Rand. To now calculate the percentage, you're going to say 25% of your total contributions are 400,000 Rand. Remember that you're working this on your previous financial year. So 25% of 400,000 Rand is 100,000 Rand. So the reserve is therefore less than 25%, 90,000 Rand versus 100,000 Rand. You'll see the reserve fund at February 2020 was 90. 25% of 400 is 100,000. So you can see that the 90 is less than 100, which means that the reserve fund is therefore less than 25% of your budget contributions. Therefore, 15% of your budget contribution for your next financial year, which is 2022, that's right at the top, is 450,000, equals 67,500 Rand. So in other words, the body corporate therefore has to budget for the 2022 financial year, the 450,000 Rand that they initially were going to budget, plus 67,500. In other words, 517,500. And again, you've got to look at your maintenance reserve and see how much reserves you have, which will also assist you with deciding or coming to the point where you either have to add this or not add it, depending on what your reserves are for your maintenance. Scenario 2, if the amount of money in the reserve fund at the end of the previous financial year is equal to or greater than 100% of the total contributions to the administrative fund for that previous financial year, there is no minimum contribution to the reserve fund. So again, we do the simple calculation. Oops. The year end, again, 2022, the budget contributions was 450,000 Rand. This is for the new year. The reserve fund at the end of your previous financial year is 410,000. Your total contributions for your 2020-21 year was 400,000 Rand. The reserve fund is 10,000 Rand more than the contributions for 2020-2021, the 410 versus the 400,000 Rand. So there's no minimum contribution required. So the budget contribution then for 2022 remains at 450,000 Rand. It is still at the discretion of the trustees to propose and for the owners to accept if the body corporate wants to contribute an additional amount to that reserve. Scenario 3, if the amount in the reserve fund at the end of the previous financial year is more than 25%, but less than 100% of the total contributions to the administrative fund for that previous financial year, the budget contribution to the reserve fund must be at least the amount budgeted to be spent from the administrative fund on repairs and maintenance to the common property in the financial year being budgeted for. Let's have a look at this calculation. Again, we use 2022 as the financial year end. The budget contributions again was 450,000 Rand, or is 450,000 Rand. And part of the 450,000 Rand is repairs and maintenance of 75,000 Rand. The reserve fund at the end of the financial year was 110,000 Rand. Your total contributions for 2021 financial year was 400,000 Rand. 25% of your total contributions of 400,000 is 100,000. So your reserve is more than 25%, but less than 100%. And the way to calculate that is 110,000 divide 400,000 gives you 27.5%. So in scenario 3, between 25 and 100%, that will determine what your contribution has to be. So therefore, your new budget for 2022, 450,000 Rand, which is your planned contribution for 2022, plus 75,000 gives you 525,000 Rand. So here you have 3 scenarios, one being from 0 to 25, the other one being from 25 to 100%, and the other one being for 100% and more. So these calculations are very, very important, especially in conjunction with your maintenance, repair, and replacement plan contributions, because this will determine what your contributions then have to be to your maintenance reserves. Fidelity Fund Insurance. So the Fidelity Fund Insurance, again, we go back to the CSOS Act and specifically Regulation 23, which deals with insurance. And the reason for your Fidelity Fund Insurance is for the body corporate to cover itself for the loss of money belonging to the scheme. So in the olden days, before the Act changed, bodies corporates were not obligated to take out any Fidelity Fund Insurance, and there was generally understanding or requirement from scheme executives to say that, well, managing agent, you are managing our funds, so you need to ensure that you cover your staff potentially for any money disappearing from the bank account of the scheme. In the new regulations, as you can see, it's now it's a responsibility of the body corporate to ensure that they have Fidelity Fund Insurance, and the people or the insurable persons in this case are scheme executives, so that's trustees, employee or agents who have control over funds of the scheme, the managing agent, and then contractors or employees directed by the managing and having access to funds. To be honest, I've never seen a contractor or employee directed by a managing agent to have access to scheme funds, but that's what the Act states. So those are the potential insurable persons in this case. So what happens when there's a potential loss? So the Fidelity Fund Insurance, no proof, as long as proof of loss has been provided to the insurer, then they will pay out the loss suffered by the body corporate. No civil or criminal proceedings need to be applied for or is required to submit a claim against your Fidelity Fund Insurance. And as long as the insured person proves that cover is in fact in place. So the body corporate has to prove that they've got Fidelity Fund Insurance in place. And there are 2 kind of points that's quite important, that the insurer must note that the scheme is in the proceedings or is in the process of applying for Fidelity Fund Insurance due to loss of funds. And then there must be an undertaking from the insurer not to cancel the policy within 30 days after they've been informed of the proceedings that's taking place. What we're finding these days in the insurance industry is that you'll find that your body corporates will have its normal insurance policy for replacement values, and then there will be a separate policy only dealing with the Fidelity Fund insurance. Some policies do actually have Fidelity Fund insurance as part of it, but I think it's more common to see a separate policy for Fidelity Fund insurance than it being part of the replacement value insurance. And then there's also a calculation which is important to consider. So at the end of each financial year, the body corporate needs to do a calculation to determine what their Fidelity insurance should be. So it's a very simple calculation: total value of investments and reserves at the end of the financial year, plus 25% of operational budget for the current financial year. So as an example, you'll see there the financial year was 2022. The previous year was 2022. This scheme had investments and reserves of 800,000 Rand. The operating budget for the next financial year is 285,000 Rand. 25% of 285,000 Rand equals 71,250 Rand. So the Fidelity insurance for this scheme for the 2022-2023 year should be 871,250. What's also important to consider here is that a scheme might, during the year, through different means, for instance, have a growth in reserves for whatever reason. And it's always important for the scheme executives, together with the managing agent and obviously the broker, to ensure that those reserves are sufficiently covered during the year. You also have the reverse, where the scheme might use a lot of their reserves for maintenance issues or items, which means that reserve will reduce, and the total amount that they need to be covered for is then less than what they had at the beginning of the financial year. I can tell you that the premiums are not very are not excessive, but there are schemes with quite big bank accounts. So it's always important just to consider this, because you don't want to use or spend money on something that you're not really being covered for. So I'm basically at the end of this training session. The slides will be circulated to everybody. You'll see there the resources. If you click on that link, you'll go straight through to the legislation that's on the CSOS website, as well as the adjudication orders. On the adjudication orders there, I mean, they're really thousands and thousands of orders there, but it's quite interesting. If you're bored, you'll find it interesting to go through some of those adjudication orders to see what kind of adjudication orders are put forward to the to CSOS. Okay, I'm going to, if there's anybody that's got any questions on the chat box, you're more than welcome to ask, and I can try and deal with them now. Okay. All right. Okay, I've unmuted myself. All right, Mr. Kevin. Okay. It's going to be taken around 6 months, but it will vary on type of application. Yeah. So just a Kevin, for a note from Kevin saying that the scheme that is involved in taken about 6 months, but 100% right, it will vary on the type of application whether it finally goes to an adjudication. So it really depends on what kind of matter is put forward to CSOS. Annalisa had a BC that withheld an insurance payout, and this took 2 to 3 months for CSOS to call an adjudication between the parties. It didn't need to go to adjudication. Agree. Annalisa, yeah, I mean, that's really should never have gone to CSOS, quite frankly. Your broker should have been involved in that, I guess. Justin, yes, the slides will be circulated to everybody, and the recording, Annalisa. Arthur, yes, Arthur, just to advise, so what happens is that the insurance brokers make contact with us 2 to 3 months before the renewal of each policy. And they then ask us to calculate the reserves so that we can provide them with that information. On the replacement, the replacement insurance policy, that we require the trustees to review, and normally, depending on when in what cycle the body corporate is, we will either get a valuation, and then the trustees can make a more informed decision on what the insured value will be. But on the Fidelity, yes, we actually calculate that on behalf of the scheme. We normally check that with the trustees. If they're happy with that, we then go ahead and give the brokers the information. Aviva, yeah, look, I mean, like I said, it's not an exhaustive session, but yes, there are ways of calculating that, how much you should have in your reserve. Regulation 2 is certainly your very first point of calculation. The only reason for that is because we just find that a lot of schemes don't necessarily always give the attention to the maintenance, repair, and replacement plan. And that has a major impact, specifically going forward when you've got major capital expenditure and expenses that you want to incur. And also, if the body corporate really doesn't have funds from the past, then you are going to find yourself in a situation where you might have to put quite a bit of money away annually to get to that point. Arthur, yes, we do. So I can tell you that we do that annually. We went through a massive exercise during January and February, so yes, we do. But again, that's one of the functions of your broker. The broker will make contact with the managing agents, and we then ensure that that is put in place for the scheme. Kevin, the 10-year plan is a starting point of calculating that. The manager agent may be able to assist in drawing up a 10-year plan, but it may be better to get an external consultant to assist. Yeah, just on that. We generally don't get involved in preparing 10-year maintenance plan, purely for the sake that we are not building consultants. We don't really know what the costs of building materials are, like how much does it cost to replace a roof, how much is it to place gutters, those kind of expenses. So we do rely on external contractors, or we call them, it's really not a contractor, but consultants, to assist schemes with those 10-year plans. Obviously, on smaller schemes, sometimes trustees do take it on themselves to do that, but it might be risky, especially when you go forward with bigger expenses. Tandy asked, what powers does CSOS have to enforcing the adjudication orders? Well, Tandy, ultimately, when they do provide an adjudication order, that effectively can be taken to the courts and be made a order of the court. I can give you an example where we one or two of the schemes that we've been involved in, where an adjudication order was made against an owner, and the owner was informed about the adjudication order and given the opportunity to, in this case, was to repair a balcony. The owner ignored that order and request. The trustees then asked an attorney to get the adjudication order made an order of the court. So the minute it's made an order of the court, you're in a little bit more trouble than what you just, being given an adjudication order. So there's quite a lot of power involved in an adjudication order, and especially if it gets converted to an order of the court. Yeah, I see Kevin's answered you there. Just going easily be made. That's correct. Aviva, you can find a consultant. Aviva, you're more than welcome to email me. I'm not sure exactly what consultant you're referring to, but we're happy to assist. Annalisa, to qualify the body corporate I was referring about was not measures, was supposed to work through a trustee, and hence the need to go to CSOS, and I was ignored, and the broker needed trustee permission. Yeah, Annalisa, I hear you. I really shouldn't have gone that far, but I hear you. Qualisure, there we go. Qualisure is one of the consultants. There's about 2 or 3 other ones. Happy to share that information. So advice from Intersect to us is not to use Qualisure. Yeah, Arthur, I mean, we do use QualiSure. I don't think it's necessarily not to use them. I think maybe just to clarify that comment, there are certain consultants that do 10-year maintenance plans. What we really want from the consultants is to provide us with a 10-year forecast where they calculate what each section in the scheme has to contribute on a monthly basis within that 12-month period towards the maintenance reserve. And that's quite a complicated calculation. And that's really why we prefer or choose to use consultants who can actually provide us with that information, because you've got to remember, doing the actual maintenance plan and putting figures in how much money you should be spending every year on the roof or make provision for the lift that needs to be placed in 5 or 10 years' time is one part of the calculation. But it's hard to get to how much each owner must contribute towards that plan, which is very, very important, because that because obviously that needs to be recovered from each owner once that plan has been approved. So it's not necessarily that we don't use QualiSure. I can tell you now that he's been appointed at 2 schemes that I'm involved in, but it's really just about that calculation. And like I said, if you look at the Act, you'll see that the calculation of that contribution is actually quite complicated. Sorry, I see somebody's got a hand up. I'm not sure who that is. Andy? Andy, I think you're on mute, or maybe if you want to type it in the box, you can put it in there. Okay, so while we're waiting for Andy to put his question in the mute bar in the box, yeah. So just again, the recording and the slides will be circulated to everybody. We will have another session next month. If you have any suggestions or anything specifically that you want a little bit of training on, you're more than welcome to either put it on the chat box now or email me separately. More than happy to accommodate any suggestions that you might have. And then also just another kind of training session that we are planning, or training sessions that we put it that way, as a much shorter kind of training session, maybe 5 or 10 minutes, or maybe even 15 minutes, where I invite experts in the industry, and I'm using just somebody that comes up, a plumber or electrician, or somebody that does a 10-year maintenance plan, to understand their role and what they do within the industry, and what their benefits are for scheme executives or for managing agents. So once we have that set up, that you will be informed about that, and it will also be more of a Q&A kind of scenario where you can ask questions to those people. So just to really give everybody a little bit more exposure to those people that you might just see on an email, this plumber or that electrician. So to just understand the difficulties that they have dealing with bodies corporate, or the fact that steel prices are going up, those kind of scenarios. So people are a little bit more understanding of other kind of industries in the sectional title space. I see that Andy has come through. Kevin, I'll come back to you now. Okay, so Andy, CSOS issued a practice directive for praise in relation of trustee liability for spent unauthorized money. Is this retrospective to trustees having spent unauthorized money 2 years ago? Andy, I can't really answer that question. My logic says that from the dates of that adjudication order, that will really become effective. I don't necessarily know that retrospective action can be taken against anybody in this regard, because also remember that when you go to CSOS, it's specifically between one party and another, and it's not necessarily, it's not a blanket action. When you live in a scheme, you are taking somebody else in the scheme, or the trustees in that scheme to CSOS for whatever the case might be. So I can't really answer you 100%. I'm more than happy to find out. It is a good question. Just also err on the side of caution with regards to CSOS's practice directives, because they do issue practice directives which sometimes are actually not enforceable. Also remember that practice directives given by CSOS still need to comply with legislation, the various acts that are applicable to community schemes. So there's CSOS as good an idea as it is, and it's not a bad idea. It's good that there is a body like this. There are quite a lot of issues with CSOS, unfortunately. And I'll give you a very simple example where one matter, let's say in the Western Cape, compared to the same principle, the same matter in Gauteng, for instance, you get adjudicators, obviously, that are in different areas, where the adjudication orders are contradictory to each other. So in the one case, the adjudicator will rule in favor of the one party, and in the other case, the adjudicator will rule against, will rule for the other party. The problem that you have there is that these things are made an adjudication order, and the only way that you can fight that if you feel that the adjudication is not fair or reasonable is to go to the High Court, and we all know that going to the High Court is an extremely expensive exercise. So there are these issues that come up regularly. If you speak to attorneys that specialize in sectional title law, you'll find that there are various examples of situations like that. And yeah, that's 100%. I'm more than happy for you to send me a mail on that. I'm happy to look at that. Kevin asked if Intersect uses the MRP functions built into WeConnect. Kevin, are you referring to the actual budget when we talk about the budget, the actual versus budget? I'm not sure if you're still on, Kevin. If you do, we can always chat offline on that. But we do use it for the maintenance, repair, and replacement plan, the actual versus budget. We do use that. I'm not sure if you're referring to that specifically. Okay, people, if there aren't any more questions or any suggestions for the next session, please, you're more than welcome to email me. I'm happy to deal with any questions that you might have after the fact. If you think of something later on, please email me. You're more than welcome to do that. I'll respond to every single one of you. Thank you for your time. I hope it was informative. And yeah, look forward to the next session, and I will see you guys soon at one of your schemes. Thanks so much and have a good evening.